It will be on the third Tuesday. But my name is Jason Rayford. I'm founder and president of the National Association of Christian Lawmakers. I'm actually here in Washington, D.C. today. And I want to, we wouldn't be the National Association of Christian Lawmakers if we didn't pray to open the meeting. And I would like to ask Representative Pearson if he is able to, Cannon Pearson from the great state of New Hampshire, if you would give our invocation, and then I will briefly introduce our moderator and we will begin the program.
Would you pray with me, please? Gracious God, Heavenly Father, Jesus told us that it is the truth that sets us free. But that truth has to be not compromised, but it has to be with love and with power. We are facing a foe, O Lord, that claims to be the primal religion, and yet it is of the deception of Satan. Help us to be wise. Help us to so know that greater is he who is in us than the one who is in the world, that we can go forth in spiritual battle and expect the victory. Bless the speaker's words that they may be true and they may be helpful, and help us to understand what we are to do with them. We pray these things in Jesus' name. Amen.
Amen.
Amen. Thank you, Cannon Pearson. A couple of just housekeeping items for you, and then we will get started here. And thank you all for making this a part of your day. A lot of legislators are still in session around the country, but just a couple of things to note, especially for NACL members that have on some of the internal meetings. This is an open policy briefing. Anybody that has registered can attend. And so we actually have, I think we were pushing 70 a couple of hours ago. I see nearly 50 people that's already on here. So just a reminder to everyone that what you say and participate in this meeting, we don't have control over who might be recording or taking notes of the meeting on the other side. I do know at least one person that is in the media had signed up to watch to participate or observe the meeting today. What I would ask you to do is to reach out to us if you are a media person and you actually are part of this. You may have some follow-up questions and want to have some further information. I would invite you to email Bob Ballinger. That's bob.ballinger. He's going to be the moderator. You can email bob.ballinger@christianlawmakers.com. You can obviously email us through the website. Many of our emails are on the christianlawmakers.com website. We're looking forward to this. This is a great start for this first-time policy briefing that's going to begin to be held monthly. Appreciate Bob. I want to say a few words about him and then turn over the rest of the panel to him for the endurance of this today. Senator Bob Ballinger serves not only in the Arkansas State Senate, he actually served in the Arkansas House of Representatives as well. He actually is a licensed attorney. He serves currently as the chief legal counsel for the National Association of Christian Lawmakers. In addition to his legislative experience and his experience in the practice of law, he also served in the Alaska legislature there as well, utilizing his skills to serve them for a couple of years. He was the original charter chair for the NACL in the state of Arkansas, and we're very happy to have him continuing on with us here today and being the moderator for this panel. With that, Bob Ballinger, I want to turn it over to you, and I want to thank you for all that you do to make NACL successful and for putting together a great panel for everyone today on a very, very important topic.
Yeah, thank you very much, Jason. This is an important topic, which, for this being our first policy briefing, we're going to be doing these monthly, but this being our first policy briefing, the attendance is great. And it's not because we're that great, although, I kind of pretty partial to us, but it's because the issue is so important. So, and the speakers that we have involved today are some of the premier experts who've been dealing with this issue. Frankly, before it became really vogue to deal with, they've been addressing this issue for a long time. So it is, the uptick, or at least a perceived uptick in Islamic violence is something that is a real issue. And I think you're going to hear that from our panelists. I don't want to take anything from them, but the reality is we have a very difficult and unique issue that we have to deal with. How do you handle a religion that's also a political movement that has at its heart and its core the destruction of the United States? And then, frankly, they're now involved in our government. They're in our communities. How do you address it and still maintain the First Amendment protections of free exercise? I think this is a good issue. NACL has taken up this mantle and passed two pieces of model legislation that are direct on point. One of them is American Law for Americans Court. It's been around a long time, and a few of our panelists have been involved. In fact, I think all of our panelists have been involved in that effort, including Dr. Brant Smith, who, when we're in the House together, carried American Law for American Court. The other thing is Andy's Law that deals directly with the funding, the resources that go into terrorism. That was carried by our president, Jason Rapert, when he was in the Senate. It was one of the first bills that came through and passed way back when I first got in the legislature. So anyway, these very important issues. Let me briefly introduce our panelists, and then we'll get right into the discussion. So Christopher Holton is a guy that's been engaged with NACL, engaged on this issue for a long time with the Center for Security Policy, and he's going to have the opportunity to share a little bit about what they do on a broad sense. And frankly, they have free reign to address the issues, as long as we stay on point of how do we deal with the issue of Islamic violence in the United States. Then Dr. Brant Smith, who I briefly introduced, he was a fellow colleague of mine, served in the Arkansas House. He's also been a missionary overseas, spent a lot of time in Muslim territory, has a very unique view on things. Kyle Scheidler, sorry, Kyle, who's also with the Center. He's an analyst with for Homeland Security, Counterterrorism with the Center for Security Policy. Julie Pickering is going to be on here. I did not see her earlier, but I know she plans to be here. She may be in now, but she is on
She's here.
She's here. Good deal. So she's on the Texas School Board. She is our chair of international relations within the NACL, and they've done some great work in Texas, and I hope she has the opportunity to share a little bit about that. And then Stephen Galil, who's the general counsel for Center for Security Policy, has worked directly on drafting some of this legislation. So just for everybody who's here, the plan is to let each of these folks speak for about 7 minutes, kind of present their issues, things that they see. Then there'll be some interaction between the panelists. And then if you have questions, please put them in the chat. And then if we have time at the end, then I will take those questions and present them to our panelists. If you have a question for a specific panelist, make sure you put that in the chat. If it's generally for the panelists, then just leave it open. So I'll start with Christopher. If you wanted to give a little bit more of your background, that'd be great. And then you've got the floor.
Thank you very much, Bob. And thank you, Jason Rapert, for everything that you're doing with the National Association of Christian Legislators. It is a honor to be here, and it's a pleasure to be here back with two of the pioneers in the fight against Sharia, which is the code by which Islam operates. Brant Smith being the author of American Laws for American Courts in Arkansas, and Andy's Law got its name from Jason Rapert. It wouldn't be called Andy's Law if Jason Rapert had named it Andy's Law. Of course, it was named for Private William Andy Long, who was assassinated by an Islamic jihadist on June 1st, 2009 in Little Rock, Arkansas, outside of an Army recruiting office. Senator Rapert at the time was the sponsor of Andy's Law in Arkansas, and it is passed in several states in addition to Arkansas. The one thing that I think is important to understand is that there are two types of jihad. There's civilizational jihad and violent jihad. And America is being targeted by both. But the underlying doctrine for both of those is Sharia. And Sharia is what we should endeavor to study and understand and battle back against. That having been said, the problem that I see today across the country, including currently in several states with legislation, is everybody's looking for a silver bullet. They want one piece of legislation to slay the Sharia dragon. And the reality is, if you look at the prominent Sharia law textbooks, they're all thousands of pages long. There is no one bill, no one law that can take care of all of Sharia. We're going to be in a multi-year battle against this doctrine, and we're going to have to fight it not just legally and not just through legislation, but culturally as well. The conservative movement has been criticized for a long time for not doing a good job of fighting the culture war against the left in this country, but we have to fight the culture war against Sharia as well. We don't want to end up like Western Europe has ended up, where Sharia has creeped into their society, their legal system, and has transformed many of these countries into the point where they're not recognizable anymore. So there are many solutions to different aspects of Sharia that can be examined, and I think that we'll cover some of them today, but there's a lot more to be done in the years ahead.
Thank you very much, Chris. I appreciate that. And I'm sure we'll get a lot more detail as we go along. Dr. Brant Smith, if you don't mind stepping up next and kind of give a little bit of your background and then what you see as solutions. And just for the individuals, I have uploaded the two model piece of legislation that we actually just visited about, American Laws for American Courts and Andy's Law, into the chat in case you want to download it. And those are available on our website as well. But Dr. Brant Smith, if you want to take the floor, it is yours.
All right. Thank you, Bob. I appreciate the opportunity to share some of my experiences. I feel like I'm in good company with Christopher and Jason and you and others. I would, in the way of encouragement, though, I think many in the United States have finally awakened to the problem that we're now seeing across our nation with radicalized Islamists, with these communities that are wanting to develop their own really small compounds where they operate based on the Quran. And you can't, as a Muslim, live by the Quran if you are not following Sharia law as well. And so they're joined at the hip. And to be a good Muslim is to also follow Sharia law. But I became aware of the dangers of Sharia law after having spent 65 months or so in the Middle East, Iraq, living there, and first as the director of an NGO, and then later 2 deployments with the United States Army. But my role was to interview local nationals and bring back intelligence information to the brigade commanders and battalion commanders. And I would often ask local nationals what they thought about Sharia law courts. And many of the people that I actually sat in front of said, I want to be free. Sharia law is bondage to our family, to us. And we would travel out to Amman, Jordan, and read the newspaper. And it seemed like weekly there were honor killings where some female was murdered by her own family because she stepped outside of the family gate without a male with her, and would be stoned to death or beaten to death by her own family. And so when we think of Sharia law, you have to think it is a system of a legal system, less religion, more legal, and it places people in bondage. Women are considered lower than livestock in that culture with Sharia law. And so it took 5 terms for us to get that bill passed through the Arkansas legislature. Two terms before I was elected, and then 3 terms for me carrying it every term for the general session. And I could not have done that without Christopher Holton being available to encourage and to help me with that bill. But it seems like now, with everything kind of unraveling all across the United States, legislatures are starting to realize that we've been asleep and we've got to step up and do something before we lose everything, including our country, because we know that Sharia law is incompatible with our U.S. Constitution. It's incompatible with the Arkansas state constitution as well. And so I would encourage every legislator on this Zoom call, don't be afraid to pick up the American laws for American courts. There's opportunity for you to customize it for your state and make it available to your colleagues. You just need to, by faith, just step out and be bold and courageous and sponsor that bill to make it unpalatable for these imams and clerics that want to set up Sharia law courts in your state, because once they're there, it's the camel's nose under the tent analogy, where you've lost if you don't get a hold of it before it's too late. And so with that, I'll pause for now and come back later if someone has questions for me.
Thank you, Dr. Smith. At some point, I hope somebody will go over and talk a little bit about what America's Law for American Courts is, what that legislation does, and what Andy's laws does. But we can save that for questions afterwards if it's not part of anyone's package. So, Ms. Pickering, if you are available, we'd love to hear from you, and specifically some of the things that you all have done in Texas to address this issue.
Yes. Howdy, Bob. Hi, Jason. And
Thank you.
I see so many wonderful patriots and friends on this call. So just howdy, y'all, from the great state of Texas. But yes, I did not have it on my bingo card. And during this last year of actually coming face to face with terrorists in education. So, but it happened that way. If y'all don't know, back in September of last year, the Council on American Islamic Relations started appearing before the Texas State Board of Education, making their demands on what they wanted included in public education and what they didn't want included in public education. And so it was very interesting. Governor Abbott declared CARE a foreign terrorist organization, reported them to the Joint Terrorism Task Force, opened up a criminal investigation into CARE and all of their affiliates, and then began a formal investigation through our Texas Rangers on all of their assets. And so it's been interesting to watch this play out, because then Governor DeSantis, I think about a month later, kind of did the same thing in Florida. But I didn't have this. I didn't see this coming, to be honest. So I didn't have any legislation to block it or prevent it. But it was very interesting to what they were demanding. So I guess I've learned a lot about it, actually walking on the front lines, fighting against them. There is definitely, what I've come to learn is the Red-Green Alliance. It is very real. The organizations and the associations and the PACs in our country and in my state that are aligned with Marxist values have definitely aligned with the demands of the Islamic, I'm going to say radical Islamic, or this Islamic. I think somebody used the word jihad. Okay, so when they held a press conference and at the Capitol. Actually, they were very mad at me because I appointed David Barton to be an official expert advisor to the state of Texas. That was the straw that broke their camel's back, and so that's when they came and held a press conference in Austin to have David Barton removed, demanding I be removed from office, which didn't go anywhere. But anyways, in that press conference was I don't want to if anybody if you're a Democrat on here, okay, but it was the Democrat Party that participated in that press conference. It was the teacher unions, American Federation of Teachers. It was one of the freedom networks that I like to call the Anti-Freedom Network, definitely a Marxist organization. So you just and the associations of school boards and several teacher unions. So you just saw this alliance come together, pushing this radical rewrite of U.S. history. And what we walked through in that, which started September of last year, is it was as much what they didn't want as what they did want. Okay. So their demands were they didn't want us to teach presidents. They didn't want us to teach founding documents. They didn't want us to teach Thanksgiving. They wanted George Washington's Thanksgiving address, which is a National Archive presidential speech. They wanted that removed. They wanted everything around Thanksgiving and everything around patriotism. They wanted it gone. And so that struck me as a little bit strange. So I started praying about it. I said, Lord, why is it that? Why out of everything? Why is that what they want? And the Lord said, when I was praying, I felt in my spirit that gets to the heart of America. If you can end thankfulness to God, if you can end thankfulness, or what a lot of us grew up on, the attitude of gratitude, right? If you can change America's attitude of thankfulness to God, you really can create a lot of hostility and resentment towards founding fathers, founding documents, and patriotism and the founding of America. And then the other piece of it was just pride in America. I don't think we have arrogance in America. At least I don't see that among this group. But we are proud of our country. We are thankful to God, and we're proud of what the Lord has enabled us to build here. And so that kind of gets to the heart of what they were wanting. But then, it was different. I just want to hit a couple of more points. It was very different than when I was elected 12 years ago and fighting critical race theory. Critical race theory left founding documents, right? It left founding documents, and it left presidents, it left U.S. history and Texas history intact. What critical race theory was doing was it was going to indoctrinate our students, indoctrinate our children to look at America through a Marxist lens, okay, to create resentment for America and just all the things that entails. Everyone on this call is very educated, so I don't have to go into that, but it was to indoctrinate our children to look at America through a Marxist lens. This was very different. This wasn't teaching a new worldview in our children, which would result in society, our citizens voting citizens in just a few years. This was a complete rewrite of U.S. history. They wanted us to teach that Islam was the great contribution to the founding of America and to the founding of Texas, not Judeo-Christian values, but Islam. They wanted us to teach that the Texas Alamo was built and designed to honor Islam. And I'm going to tell you how far-fetching this is. They even had one of the leading professors from University of Texas come and testify on their behalf that this was true, that this was accurate. So this isn't just some far, radical terrorist organization making these demands. That they have people with some heft behind their name and behind who they are representing their cause. And so that was one of the things. The other thing that they wanted us to teach is they wanted us to teach that the most advanced people on earth, the most highly educated people on earth, were the Muslims in Africa. They were the most advanced in medicine and astronomy and science and arts and mathematics. And they wanted us to teach that America intentionally went and enslaved the Muslims in Africa so that we could bring the most highly educated people in the world back to America to make America great. And that America was actually made great, and America was actually built through enslaving these highly educated Muslims that were brought over from Africa. So it's just a complete rewrite of history. That could go on for a long time. I mean, they gave us over the culmination of all their testimonies, they gave us about 10 pages of what I call terrorist demands on what they wanted taught and not taught. But I also have the honor of being an advisor to several European countries in the European Union. So I was in London in January, and I was invited to visit the House of Lords, which is their upper chamber. It's equal, to our United States Senate. So I was invited guest there, and I'm listening to testimony because they were going over a piece of legislation for a child, what they called a child well-being bill. And I really like to watch what's going on in Europe because they have about 5 years advanced on what's going to hit here, what's coming to America. So I really like to watch what's happening there. And it was so interesting when I was sitting through that testimony in the House of Lords, the head of their public health department, which would be like our HHS, was asking for a dramatic increase in funding for mental health services for children. And then they brought expert testimony, doctors and what have you. And the testimony was that they needed an increase in mental health funding for children because children in England and specifically London are being diagnosed with an alarming rate of PTSD due to witnessing violence and beheadings on the streets of London. And so you don't hear about that. That's not covered by mainstream news. So I thought, well, why are they asking for all these millions of dollars of extra funding? So I went and started doing my research, and it was true. When I looked at England's statistics in 2025 alone, they had 16,344 machete attacks. Some were beheadings, some were just machete attacks on just the general population on the streets of London, the streets of England. And so this is very real for them, very real that they're asking for a dramatic increase in funding for children, for mental health supports for children. So we really need to pay attention to this because what's happening there is what they fully intend for here. I mean, it's at our doorstep right now. If we don't pay attention, this is going to look like a very different fight 5 to 10 years from now if we don't get ahead of this. But in Texas, we just had a great victory against Sharia law in education. So I told you that CARE and their Marxist affiliates have been coming before my board to make demands on what we're going to be teaching in social studies, civics, government, kindergarten through 12th grade. And we had a resounding victory. We defeated all of their demands. And I'm going to tell you why that's a resounding defeat and why the Lord is so good. Because going into these votes last week, we didn't have the votes. We were losing this because CARE has endorsed all the Democrats on my board and 2 Republicans. They're not limited to one party. And so 2 Republicans on my board are endorsed by them and financially benefited from CARE in their reelection to office. So I'm just telling you, we didn't have the votes going into last week, but God is good and a lot of prayer and a lot of happened and a lot of patriots showed up. But anyway, so we defeated all of their demands. But in my world, like a lot of you, the best defense is a great offense. So we had a lot of pressure on. So I offered over 20 amendments, putting patriotism, putting the Bible, putting Judeo-Christian values firmly back into education, including teaching the Black Robe Regiment in elementary, and then coming back and teaching the Black Robe Regiment's influence, the sermons. The Black Robe Regiment sermons directly impacted the Declaration of Independence. You can go down that list of Declaration of Independence, and just about every single one of them comes from a sermon. Even England at the time said that the thunder in the pulpits of America's churches is the fire of freedom among the people in America. It lit the fire of freedom in America. So teaching the Black Robe Regiment, teaching Mayflower Compact and its Judeo-Christian roots, teaching Magna Carta and how it relates to Christian beliefs that all men are created equal. I mean, we ran the court. Like I said, I submitted over 20 amendments and passed over 20 amendments, firmly putting Judeo-Christian values, patriotism, and the Bible. So if you want to take that posture and just say the best defense is a great offense, NACL for education, NACL approved 2 model policies that I actually built all of this strategy on to go win this against the terrorist organization last week. And that's the model policy, the Informed American Patriotism and Education Act, that the NACL, it's now their adopted model policy that says, it's a state law that says in kindergarten through 12th grade, all education must be taught through a patriotic lens. You must teach the noblest through the lens of the noblest experiment and American exceptionalism. The other law is that it says whenever you're teaching anything social studies or English, kindergarten through 12th grade, you must use the Old Testament and New Testament as supplemental text. And so these are huge. They've been law in Texas now for many years, and we have drawn 0 lawsuits. So they're going to say, they always rattle the saber and say, we're going to sue you. But the good thing is, if you pass that law, Texas already passed it. We've already implemented it for several years now. 0 lawsuits. And so if anybody were to sue your state over that law, well, then Texas would, be ready, willing, and able to stand with you to defend that law. And so I say go on the offense. It's the best. You can't, like y'all said, there's so many ways that they're attacking in culture that you cannot pass enough legislation to block it. It's like water. It's coming in through every little seat, nook, cranny, hole. So you can't, you'll make yourself crazy trying to pass enough legislation to block it. So what you have to do is you have to go on the offensive. You have to say America is a nation based on Judeo-Christian values. We are going to honor the Bible. We are going to put the Bible back in all parts of society. We are going to put the Word of God back. We are going to emphasize patriotism. So that's just, for what it's worth, that's my 2 cents. And we had tremendous victory last week in defeating it.
Thank you so much, Ms. Julie, and I appreciate that. That's actually, as you started the presentation, I was thinking that is exactly right. You get on the offensive about teaching what it is to be an American, and then there's not fertile soil for people with Islamist views to get it infiltrated into our government, into our system. Like if we can keep people focused on the true history, on our true heritage, on what it is to be an American patriot, then that's probably the most effective tool. Okay, Mr. Stephen Galil, if you are able, if you don't mind, you have the floor.
Sure. I'm Stephen Gillet. I'm an attorney practicing in Louisiana. I've been consulting with the Center for Sharia Policy for about 18 years. I currently serve as general counsel. My primary role has been to assist in the development of state legislation. The primary piece of legislation the Center for Sharia Policy has developed regarding Sharia law has been American Laws for American Courts. American Laws for American Courts, in some form or fashion, has passed in about 12 states. There's a couple of bills still floating around this year. We've pretty consistently passed about 1 bill a year for the last over a decade. What the bill does, it basically says that in the several ways that foreign law interacts with American law, it states that you don't apply the foreign law unless the parties have the same constitutional rights as they would have had fundamental constitutional rights in the United States. So the way that those foreign laws interact, including Sharia, Islamic Sharia, would be comity, which is a fancy legal word for we treat your judgment or your ruling with respect. What typically happens is that there'll be a foreign judgment, normally from a foreign country, often from Islamic countries. They'll try and apply it, enforce it here within the United States. There's different statutes that apply to this depending on the context. And what American Laws for American Court states says you don't accept that foreign law, the foreign judgment. A court here won't enforce it unless the parties to that proceeding have the same constitutional rights, which would include freedom of religion, due process, and equal protection, which are often issues within Sharia law. The other issues, the other areas where foreign law will interact, one is forum nonconvenience. Sometimes there will be a proceeding filed within the United States, and one of the parties will claim, well, this should really be somewhere else for various reasons. The incident occurred somewhere else, the contract was signed somewhere else, the witnesses are somewhere else, and the legal doctrine called forum nonconvenience that addresses that, and they'll ask that the case be moved to that other jurisdiction. Kind of classic examples of this were people that were injured in Saudi Arabia. A Christian woman is injured in Saudi Arabia. She wants to sue at a Marriott resort. She wants to sue Marriott at its, by its headquarters in Delaware. Marriott says, no, we want you to sue us in Saudi Arabia. Of course, in Saudi Arabia, her testimony would be worth 1/4 of a Muslim's man, her being a Christian woman. So she says, no, that's unfair. American Laws for American Courts would say, well, no, you don't transfer that case to Saudi Arabia because she wouldn't have the same constitutional rights, particularly of equal protection. The other contexts that pop up are normally contractual. You will have contracts that will have choice of law clauses where the contract will say, well, this contract will be governed by the law of Pakistan. This contract, some of them will say basically Islamic law. They'll say the law of Allah and his prophet Muhammad, and it'll explicitly call for the imposition of Sharia law. Again, courts under American laws for American courts, those courts will not apply any rulings, will not enforce any rulings that came out of such a decision, and actually it would prohibit the court from applying that law. So if someone said, hey, we're in a dispute, here we are in a court in Tennessee, but judge, the contract we have between each other says we're going to apply Pakistani law. The judge would say, well, no, I'm not going to apply Pakistani law in this situation. The other example would be what they call a choice of venue clause, which will say, hey, you and I signed a contract. If we get into a dispute, we're going to go decide this in Saudi Arabia. Again, the court could say, nope, I'm sorry, under these circumstances, we won't send you to Saudi Arabia. We won't hold that we don't have jurisdiction because it's a choice of venue clause. And with that, the big twist within a choice of venue clause is the arbitration clause, arbitration agreements. What's occurring, particularly in Texas, is that at mosques, when women get married, they have them sign in their Islamic marriage contract, their MAR, an arbitration clause that says that if we get into a dispute in our marriage, then the dispute won't be decided by a Texas court under Texas law. It'll be decided by our Islamic tribunal under Islamic law. And that's becoming more common. It's become a political issue in Texas because of its commonality. There's cases that have come up in Texas where people have tried to enforce those judgments. And that's the other context where this occurs. We have other laws, we have other tweaks to other statutes that we call mini ALACs that can be passed that would address this in particular contexts. For example, in the free speech context, in the context of libel judgments, it would address it. We call the Free Speech Defense Act. We have a potential amendments to the UCCJA, the Uniform Child Custody Jurisdiction Enforcement Act, which would again prevent the application of judgments from foreign countries that were applying Islamic law or other laws. There's some other laws other than Islamic that can cause trouble, that won't comport with American concepts of due process or equal protection. Some issues with, for example, Japanese custody judgments. So in those contexts, these statutes are a little more narrow, but they are basically mini ALACs. They address the same issue as ALAC. So far, where these laws have been passed, not one of them has been challenged in court for its constitutionality. Originally, Oklahoma passed an amendment at the very beginning, and that was challenged, but that was not American laws for American courts, had totally different language. So the language is important. It is possible that if this is done without thought, that you could find yourself in a constitutional challenge. American laws for American courts, though, has never been challenged. Needless to say, lost a challenge. So how you go about doing this is important. With that, we have other statutes such as Andy's law, some terrorism laws, some other things that can deal with these issues. But American laws for American courts and its variants is the #1 legislation that can help defeat the infiltration of discordant foreign law, including Islamic Sharia, into the United States.
Thank you, Mr. Gillette. And sorry I got your name wrong after getting it right when we first met. So, okay. Well, so we do have a couple of questions that the audience has presented through in the chat, but let me start with the panelists themselves. Do you have anything that either from the conversation, something that needs to be brought up and shared that was sparked by one of the other panelists, or do you have a question for one of the other panelists?
This is Christopher Holton. We haven't heard from Kyle Scheidler, our director.
Oh, I am so sorry, Kyle. I am so sorry. Yeah, Kyle, you are next. I apologize for that.
Well, I'll be quick because I think people want to get into the legislative conversation, and that I think is very important. I want to just very quickly do a run through of some of what we're seeing on the violence side, on the terrorism side, because obviously, these things kind of go hand in hand. And this is one of the challenges actually we've had in addressing this issue is there is a tendency when talking about this topic to think about it solely from the context of terrorism and or alternatively to think of it solely through the context of culture. And actually there's elements of both at play here. And I think one of the good ways to think about it is if we think about what is taking place as a sort of armed subversion, that is that the violence that we are seeing is especially right now, we're almost 20 years after we're more than 20 years after 9/11. We're not really seeing the large scale mass casualty complex attacks that we saw prior to 9/11 and that we sort of expected to see immediately after 9/11. We are now in a stage where a lot of what we are dealing with is low intensity but highly subversive violence. These are individual acts of jihad committed by one, maybe two people. They may have no apparent international ties, which creates challenges with the way that our federal law enforcement thinks about terrorism. They divide things into international terrorism and domestic terrorism, and this can create challenges with how to think about this when you have individuals acting on behalf of a foreign ideology, but who have, who may be U.S. citizens who were born in the United States, whose parents were born in the United States, and yet they have adopted a foreign ideology and committed an act of jihadist violence. And so a lot of the challenge we have is how we think about these kinds of attacks. But that's the kind of attack we're seeing now. Din Jabbar and his New Orleans vehicular attack, the New York City bombing attempt at that counter Islamic protests that took place in New York City outside the governor's mansion, where you had two individuals who identified themselves as being linked to ISIS, attempting to bomb that crowd. You had a number of attacks committed in the name of either Iran or on behalf of Hezbollah in Texas and Michigan. But these were not the sort of complex terror attacks we would expect from a Hezbollah or an IRGC supporter. They were relatively low intensity attacks. But what this means for state lawmakers is that there's a higher likelihood that an incidents of jihad will be a kind of violence that's going to have to be addressed in your state court, that federal law enforcement are not going to identify as something that they need to address. And so making sure that you have state level terrorism laws that are up to date for dealing with the kinds of violence that we tend to see is very important. And making sure that you have material support laws that will enable you to go after the networks that may be educated, recruited, indoctrinated these individuals to conduct these attacks. When, very often, unfortunately, what we see is at the federal level, things have improved maybe a little bit, but still at the federal level, we don't see a really aggressive prosecution of those elements of the network that may have materially supported these attacks. Very often what you see, as we saw, for example, in the New Orleans attack on New Year's, was the FBI identified that he had operated on behalf of ISIS or in support of ISIS. He was linked to a local mosque in Houston, Texas, but that's where the investigation really kind of came to a halt. All of the major questions that federal law enforcement wanted answered, they had answered. And that was not necessarily satisfying for state and local law enforcement. And so I think if you think about developing state statutes to authorize your law enforcement officers to pursue those kinds of investigations under state law, you can, I think, create a little pressure to make sure that federal law enforcement addresses terrorist threats the way they ought to. And secondly, that if you're not happy with that, the state, when there's a terror attack, the state is an aggrieved party. The it's an attack against the U.S. Constitution and federal law, but it's also very often an attack against the state constitution and state law. So you have to say, the state that you're in is an aggrieved party, and they have certain rights, including prosecuting those crimes and prosecuting those who materially supported them. So that's something I would encourage you to do, and you can talk to Stephen and Christopher about some of the ways that we can help you do that. But I definitely see, as things develop, there's going to be more need for local and state law enforcement to be involved in counterterrorism efforts rather than less. Another reason for that is we're seeing a lot of crossover between groups and ideologies at this point. The example that I would give you, there was a vandalism attack against a Pittsburgh synagogue in Pennsylvania, where the two perpetrators were an individual named Mohammed Hamad, who identified himself as a Hamas operative or a would-be Hamas operative, and a Jewish woman named Talia Lovett. And she was apparently hardcore leftist, anti-Zionist. But these two people were in cooperation. They had different ideologies, but yet they were able to cooperate to conduct this attack against a synagogue. So that is going to require better education about the kinds of threats that you're likely to see, because your law enforcement are going to have to piece together what the motives were in these attacks, and increasingly that's getting more and more complicated to do. So they need better education than they're getting right now, and we have a program to help with that as well.
That's great. Thank you very much, Kyle. And that's what, as Kyle was talking about legislation that you can do at state level that will that allows them to address terrorism as a state crime and allows them to get at the source of funding. That is the heart behind Andy's law. So that is one of the two model pieces of legislation. And it may be called different things, different places, and they're working on that issue. But that is, the original version, Arkansas version, was Andy's law. Well, thank you guys very much. Are there any questions before we go to questions from the audience, from the panelists for each other?
If I could ask Stephen Gillette, I wanted to explore a little bit further Oklahoma. In 2010, Oklahoma passed State Question 755, and Stephen alluded to this, and it's very important for going forward. They passed a constitutional amendment which said no Sharia in Oklahoma, essentially. Very short, one or two sentence piece of legislation, and it passed with 75% of the vote in Oklahoma. Unfortunately, as a lot of legal scholars predicted, the amendment was struck down in federal court. In fact, it was struck down by a Reagan-appointed judge. And then when it went to a federal appeals court, they upheld the judge's ruling unanimously. And then Oklahoma shifted gears and passed American laws for American courts. But the problem with what they said was when they specifically delineated Sharia, they violated the equal protection law of the Constitution and the Establishment Clause of the Constitution as well. And there was a practical problem with it too that never came into the legal machinations. But if we pass a law in any state that says no Sharia in this state, and then a dispute happens in a legal case, and they go before a judge, and one side accuses the other side of trying to apply Sharia, the judge probably didn't go to Sharia law school. He probably went to a local state law school. And so he's going to have to decide whether Sharia is being applied here. Where is he going to go to find out if it's Sharia or not? Well, the only place he can go is to a local Islamic authority. And in other words, the very law that was designed to keep Sharia out of the court actually ends up bringing Sharia into the court. So that was the problem with the Oklahoma state question. Unfortunately, we're seeing that come back up now 15 years later, in a few different states, we've managed to pass American laws, American courts in Idaho, and they recently passed it in Florida as well. And in addition to that, we've got good progress in Missouri with American laws, American courts. We've got our fingers crossed, but we're also seeing bills that specifically mention religious law and Sharia, and the problem with those are that it's not necessary to name those, and when you do, you run afoul of the Constitution. And I'd like Stephen to comment on that.
Yeah, I would note two things there. One, Chris described the constitutional rulings very clearly, that the courts will both run to the Equal Protection Clause and the Free Exercise Clause, and basically say you can't ban a religious practice. And if you characterize it as that, another problem is that you ban Sharia is that a lot of Sharia is religious practice. So you can't ban people praying 3 times a day. So that's an inherent problem with using that verbiage when you're writing a bill. We came up with a way of doing this in a facially neutral way, where it doesn't only include Sharia. I mean, there are instances of foreign law that are not Islamic that violate American fundamental constitutional rights. It's a practical matter. The vast majority of what we're dealing with is going to be Islamic Sharia, but a percentage of it's not going to be. But because it's facially neutral, you can, for example, the courts are very clear, you can always ban certain conduct. So, there's numerous cases where people claimed something was religious and the court said no. For example, polygamy, smoking peyote, wearing masks. The Ku Klux Klan claimed that it was a religion and that they should be allowed to wear masks. The courts have repeatedly said no to that. So as long as it's characterized as, hey, you're applying foreign law that violates American constitutional rights, then you're not going to have the constitutional issues. The moment that you run towards naming religions or naming Sharia, you're going to have the constitutional issues. And we track cases nationally. This is an imperfect process because the district court cases are very hard to track, but appellate cases we can. And we have noted a decrease in the attempts to apply Sharia law within the courts. And I think the reason for that is that they know that these, particularly in the states where we pass these statutes, that they realize that with increased awareness, and this particular statute has been effective in preventing that. The only other thing that I would note from a practical point of view is that this does have ultimately a larger effect beyond just the particular cases or these particular issues. If you want to come to the United States, Muslim or non-Muslim, to follow American culture and American law, then you're fine. If you want to come to the United States and follow practices that are not allowed within American constitutional norms, then you're going to have problems. And for Muslims that want to come here and be completely Sharia compliant and force others to be Sharia compliant, it's not going to work. And that in and of itself will discourage the kind of cultural changes that I've heard concerns about. So, you begin by saying you can't enforce your will through the courts. And then at that point, you then limit the attractiveness of being here for people that do want to enforce Sharia law upon others. And that's not a complete answer, but that's a beginning to limiting cultural changes that we don't want to see.
I have a question actually following up on that, if you don't mind.
Yep. No, go ahead. Yeah, we'll go right up to an hour. If folks have to get off, they can. But I'd say this has been really, really effective. So I would recommend folks staying on, and we'll go over just a little bit in order to be able to cover our territory. So yeah. So Kyle, go ahead.
Sure. So one of the things that obviously raises, because American laws for American courts deals with the infiltration of foreign law into the court, but it creates the problem where you have activity outside of the courts that are essentially functioning as courts. And I'm thinking here of Islamic tribunals. The one most people are probably familiar with is the North Texas Islamic Tribunal. It's managed by a number of very radical clerics with ties to the Muslim Brotherhood, um, and have some pretty extreme rulings. But that is essentially operating as an arbitration, a panel of arbitration, in that two individuals have willfully chosen to submit themselves to that tribunal as an arbiter. So, Stephen, what can we do in terms of addressing that sort of challenge, where you have individuals utilizing essentially Sharia courts outside of the American court system? Do we have any opportunities there?
Well, I think there's three things. One, laws like ALAC will prevent the enforcement of those rulings. So even though they may go even let me say something to say, hey, you're about to get married, daughter, sign this piece of paper, and she signs it. It's something else when later she's told, hey, if you want to leave your husband, you're going to lose your kids. At that point, the wife or whoever's been wronged by the arbitration panel, in our view, would have the ability to run to a court or just refuse to obey it. Just say, I'm not turning over my kids. The husband runs to a court and says, hey, enforce this, and the court says no. So the first thing is that by making those things not enforceable, it cuts into their ability to work. Secondly, we can try and inform people of their rights. Like, hey, you may have gotten some arbitration judgment that you don't like, but that doesn't mean you have to follow it. You can run to a court and fix that. And then the third thing is trickier, and we haven't really gone down this road. It is possible that if you had these courts that were truly parading as courts, then there might be ability to do some limitation on their nomenclature. You can't call yourself a court when you're an arbitration panel. So that is we haven't gone down that road, but that is a potential road if we saw these arbitration groups basically declaring themselves courts and acting like they were courts. Then you might be able to limit that, much like you can, prevent someone from parading around as a police officer when they're not a police officer. So that I think those three ways are our opportunities, but you have to start by passing something like ALAC. And then from there, you can inform people of their rights. And then from there, you can say, okay, well, these people are parading as courts, but they're not, judges, and they can't do that.
If I might add, the majority of the cases in which Sharia has insinuated itself into the U.S. legal system involve family law. And so a lot of these arbitration panels deal with family law, particularly child custody. And as Stephen mentioned earlier, there are ways a lot of states have already passed laws to forbid arbitration of child custody. Unfortunately, Texas is one of the states where arbitration of child custody has not been prohibited. And that's why you have that arbitration panel operating prolifically in Texas. It's because of the family law.
Texas has the most liberal child arbitration statute, child custody arbitration statute in the entire country. Texas by far the most liberal on that issue. So that's and there's reasons for that. I believe it tends to be more permitted in the West. Actually, the Northeast is the most conservative on that issue. States like New York banned child custody arbitration a long time ago. I think that's a function of just the arbitration companies in those states, and also, frankly, the Northeast blue states tend to want to regulate things, and they regulated away arbitration and child custody a while ago. The other, on that note, on the second point that you can educate, there are concerns about the left seizing institutions such as social workers and agencies that deal with child services. And having those social workers and agencies that deal with child services properly educated on this topic would be a big help. Because one of the problems in these situations, which as Chris was noting, was nearly all these family law situations, these women are normally incredibly isolated. And occasionally we will find in some of these cases, the fathers will actually defend the daughter and will fund the litigation. But in most cases, the fathers will not back up the daughters. So, and if the exact opposite. So that is a problem, and the less information and the more radicalized state agencies are that deal with women and children, the more problems you're going to have, and the more difficulty you're going to have in being able to push back.
That's great. I appreciate it. Go ahead.
I'm sorry. One other quick point. One of the laws that we did pass, we passed laws regarding female genital mutilation, but we also passed laws regarding education on female genital mutilation, requiring doctors and nurses and others to be educated. So laws like that can help. I mean, it's one thing to pass a law saying you can or can do something, but the professionals that deal with that area need to know about it. So, so that's in follow up to passing good laws like banning female genital mutilation. You need to have, we also have statutes that deal with mandatory reporting of it by certain professionals, just like you mandatorily have to report child abuse or sexual abuse. So you can pass laws that maybe not that dramatic and deal with primarily bureaucrats, but those bureaucrats are important.
Yeah. That's great. We do have a question. First question that came from audience for Dr. Smith, and I think Julie Pickering hit on this just a little bit. But the question is, you try to pass the American Laws for American Courts 5 times. Where does the resistance come from? Who is the opposition? I know the answer to that, but I don't think our audience does.
Business.
Business. Dr. Smith, do you concur with that?
Well, there was a lot of concern about international businesses that do have corporate holdings or offices in our state of Arkansas. There were people concerned about what did Walmart think?
Mm-hmm.
What did the French aircraft company that's there at the Bill and Hillary Clinton International Airport, what would they do to us if we pass this bill? But I think it's almost imperative. Well, I would say it is imperative that we just simply not give up. We continued to run the bill, and then as different legislators came into the House and the Senate, more and more they began to see the need for this piece of legislation, and it just took time. It's labor intensive, and Christopher Holton will tell you that. I don't know how many trips he made to the Capitol on ALAC, but we finally accomplished it, and I would have celebrated in a much more tangible way, but I was so exhausted when we got it finally passed that I just wanted to lay down.
The only other thing I'll note to that is that one of the strong retorts we've used for over a decade is that the states that have passed ALAC, I mean, Louisiana passed ALAC over a decade ago. Behind me is the Mississippi River, where an enormous amount of international trade occurs. There's been no reports in any of the states that have passed versions of ALAC that they've lost any international business or any international companies whatsoever. So, I mean, I can understand that argument if it was the first state passing ALAC, but when you're the 13th state passing ALAC and the first 12 have not seen any negative repercussions whatsoever on business, I think you can end that. The other narrow group that fights this is sometimes there's a particular problem in Georgia. There's certain companies in certain states that do international arbitrations, and they don't like anything that negatively affects arbitrations in family law. These international arbitrations they do are typically big companies arbitrations, a Russian company suing a French company, and they specialize in that. But they will aggressively sometimes fight, and that's not what ALAC's about. So that's oddly enough where your most dangerous opposition comes from?
Yeah, the opposition from like the Muslim Brotherhood, groups like CARE and ISNA and what have you, it's not been a major factor in preventing ALAC from passing.
Right.
It's our folks.
Right.
We are the enemy.
Yeah.
We're the problem.
Yep. Yeah. It tends to be the same people that are helping us when we're working on tax cuts are opposing us on this type of legislation. One question that we had multiple variations of, and I don't know that it's an easy one to answer, but it is like, they're pointing out and they're saying, how do we stop them from utilizing our system against us? So we have a system that protects rights, that protects religion, protects the ability of speech, protects their ability to create schools that teach their doctrine, their philosophy. And I don't know that there's really an answer to that. But does somebody want to try to address that? I'll start with, hey, I'd rather have a little bit of dangerous liberty than to have safety and a totalitarian government like Thomas Jefferson. But is there, like, when it comes to Islam, how do we handle that?
Well, one thing you can do is you have to take a close look at your textbooks and what is in the textbooks. And I'm sure Julie has a lot more to say about that than I could possibly say. But that's something that is happening around the country. More and more activists are now taking a close look at the textbooks and how textbooks teach Judaism and Christianity as opposed to how they portray Islam, for instance.
Well, that's great. Well, as much as I'd like to keep this going, we are going to need to wrap up. A couple items in the chat. You'll see a little bit of housekeeping in that we do have a national policy conference coming up the 1st of June. If you go to the website, you'll see it. You can see the place. We'd love for you to sign up and come take part in our national policy conference. The other thing that I do want to point out is actually Kelly Shackelford. I think he may still be on here. I really appreciate him showing up and being part. He's the founder of First Liberty. He works with the DOJ under the Trump administration on religious liberty, and a hero to me in a lot of ways. So it's what a I hate pointing out anybody because we've got so many just incredible people who are taking part in viewing, but he is a superstar. And then the other thing is we're going to do this again on a new topic, the third Tuesday of May, and we'd love to see you. So be looking for the opportunity to sign up. And any parting comments real quick from any of our panelists?
Thank you very much for the opportunity.
Bob, I just want to commend
Jason,
you guys. Yeah, I just want to commend you. You've had really an excellent panel here. And like you say, I wish we could go on and on. It doesn't mean that you can't do this again in the future. I think that there needs to be some continual education on this matter. And I think there's an opportunity for you to do that. But I just want to commend all of you. And if you do want to be sure to be included, please email one of us on staff to make sure that you are getting an email. We sent out multiple different volleys of invitations on this, and we want to make sure that if you want to be included, that you're getting a direct invitation. So good job, Bob, and the rest of the panelists on what I think is a very, very rich conversation.
Yeah, and I will, Jason, real quick, just make sure this conversation will be continued in June as well. This is an important enough issue that we will be talking about it at the policy conference in Lynchburg. But having said that, we appreciate it, you all being here, and we're going to close out and hopefully see you again next month and then in Lynchburg in June. Thank you, guys.